Let's quickly cover the Estate of Anenberg versus the Commissioner of the IRS. Sally and her husband, decedent, established family trust after decedent's death in 2008 that held some closely held companies. After decedent's death, they made a Qtip election on decedent's estate tax return so that the property passing the marital trusts qualified for the marital deduction, even though the spouse only received the income interest. Later, with the consent of the decedent's children and the surviving spouse, the state court terminated the marital trusts. All of those underlying property that was held by the trust was distributed to S, which is the surviving spouse. The surviving spouse later sold the shares of the company in exchange for prom notes equal to the purchase price. So she sold them for prom notes, but the purchaser of the closely held shares was trust for the benefits of her children and grandchildren. The court held, and the IRS took the position that when the surviving spouse terminated the marital trust and reverted all the property back to the surviving spouse, that somehow she'd made a gift to herself, I guess. But the court held that the surviving spouse's estate is not liable for gift tax because the surviving spouse just received back the interest in property that she was holding and transferring under the code, and this is due to the Qtip fiction, which is what comes out of the case. The rules create a legal fiction under which the surviving spouse is treated as receiving all of the Qtip property, even though she only received an income interest for her lifetime. So it's a strange position that the IRS took here. And this case will be distinguished from the McDougall case, which is one where the IRS successfully argued that the children, that their consent to a non-judicial agreement to terminate residuary Qtip trusts, that was a taxable gift. But this is different because here the IRS just went after the surviving spouse, who was already treated as owning all the property anyway.